The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to today's webcast, Affordable Care Act, What You Need to Know Now. This webcast is a continuation of our webcast series to keep you informed of the current HR topics and the impact it has on your business. As always, today's webcast is brought to you by our PEO division, including Employer Solutions Group, Professional Staff Management, and Century 2. My name is David Kyle, and it is my pleasure to be serving as your moderator today from high atop Overlook Boulevard in Century 2. With all the upcoming regulatory changes and requirements surrounding ACA, you'll be hearing from our expert panelists Mary Beth Lunn from Employer Solutions Group, ESG, and Kim Troop from Century 2, providing you with updated, timely information on ACA. Before we get started, I want to cover a couple of items. At the conclusion of today's webcast, all participants will be emailed a copy of today's presentation. During the webcast today, all participants will be in mute mode, but you are encouraged to submit questions by typing in your panel, and you will answer questions as many as we can at the end of today's webinar. Now, moving along to our session, the Affordable Care Act, What You Need to Know Now. By the end of today's webcast, Mary Beth and Kim will cover the following three important topics. Refresher on the small and large employer requirements under the Affordable Care Act, key elements of the final shared responsibility rules, and the new tax reporting requirements. At this time, I'd like to welcome our first panelist, Mary Beth Lunn.
Good morning, everyone. As most of you know, over the last few years, we've all been impacted by the Affordable Care Act. And at this point, virtually all taxpayers are required to obtain basic health information, or they're going to be subject to a penalty. And that actually began back in January of 2014. Also, large employers, and that's defined as employers with 50 plus full-time equivalents, also must provide minimum value and affordable coverage to all their full-time employees. And a full-time employee is defined as someone working 30 hours or more per week. And if they do not provide this coverage, they may be subject to a tax. And you probably heard the words that this is called pay or play. There are also several required employee notices that have to be given to employees. And these include the exchange notice, or called the notice of coverage options, a summary of benefits coverage, and a revised COBRA notice. Well, in addition to all of these things, there are new tax filings for large employers. And this requires employers to track employees' hours and their employment status, whether they're full-time or part-time. And that's really going to be essential. And the tax filings, there's going to be a number of forms that they have to file, and we'll be talking about those a little bit later in the presentation. Well, now, at this point, there are current requirements. And the first of these is the employer reporting of health coverage on the Form W-2. Now, at this point, it's only required for employers that issue 250 or more W-2s. And what this means is they must include on the Form W-2, Box 12DD, the aggregate cost of the health plan. And so what that is what the employee pays for the insurance and what the employer pays for the insurance. Also, employers must give each new hire a summary of benefits and coverage, and they also must give the SBC to all eligible employees and COBRA participants at open enrollment. Now, when you hire a new employee, you are required to also give that employee a marketplace exchange notice, and that has to be given to all new hires. And if you remember, a couple years back, it also changed all newly eligible full-time employees. They must be enrolled by the 91st day. So your longest waiting period is a maximum of 90 days. Now, there are other requirements, and these are compliance requirements. And these include, and this is one that's only for highly compensated individuals, the Medicare tax on high-income individuals back in January 2013, if you made more than $200,000, then your Medicare tax increased by 0.9%, so your tax went from 1.45% to 2.35% on wages. And that only applied to, of course, those individuals making more than $200,000. Now, there's also updated COBRA language, and the change in the COBRA notice, it has to also inform individuals about their exchange options. So not only do they have the COBRA option, they also have the option to go to the exchange to get an individual plan. Now, it used to be that employers would give employees money to pay towards individual medical plans. And that's really not allowed at this point. And if an amount is given to an employee, that amount is taxable.
So I go to your box and print, do I need a code or something?
No, just go to payroll.
What did you print?
Are also, there are 3 fundamentals of the ACA. And these include the individual mandate to purchase insurance, and that began in January 1st of 2014. And at that point, all individuals and their dependents were required to obtain minimum essential coverage, or they were going to be subject to a tax penalty. Then, in January of 2015, the employer mandate began, and that's the pay or play. So for employers with 50-plus full-time equivalent employees, if they do not provide coverage for their employees, then they would be subject to a penalty if the coverage does not meet affordable or doesn't meet the minimum value standard. Now, there is some special transition relief for employers that are between 50 and 99 full-time equivalents. Now, all states are either have an exchange or participate in the federal exchange. And you may, as an employer, go to the exchange or marketplace to purchase individual or small group coverage. Now, there are a number of provisions that affect individuals. And as I mentioned, back in 2014, individuals had to have purchased minimum essential coverage or pay a penalty. And those penalties in 2015, the penalty is the greater of $325 with a maximum of $975 for a family, or 2% of household income, whichever is greater. So let's say you have a household income of $100,000, then that your penalty, your tax would be $2,000. And that actually, this amount increases for 2016. So the penalty is $695 for an adult with a maximum of $2,085 for a family, or a household 2.5% of a household income. So instead of the $2,000 in 2015, it would actually be $2,500 based on 100,000 household income. Now, individuals might have coverage through an employer, or they may purchase an individual policy through one of the exchanges. Now, employees or individuals will receive a 1094B from the insurance carrier, and or they may will receive a 1095C from the employer as proof of coverage. And if an individual has gone to the exchange or marketplace and has received a subsidy, they're going to receive a 1095A. Now, the exchanges, each state has an insurance exchange or marketplace or participates in the federal exchange. And this is the place where individuals and small businesses can go to purchase medical coverage. And on the exchanges, the plans provide minimum essential coverage to meet all the individual mandate requirements. And the types of plans go from a bronze level, which provides 60% actuarial value of the essential health benefits, up to a platinum plan, which provides 90% value. And then, of course, there are some individuals who will be eligible for a premium subsidy. And typically, this would be someone who has a household income between 100 and 400% of the federal poverty level. And so this is a family with a household income of up to $88,000 for a family of 4. They may actually qualify for a subsidy. Now, there are many ways that small groups are impacted by the Affordable Care Act. And remember that the ACA was intended for the definition of small groups that it be expanded from 50 employees to 100 employees beginning in 2016. But back on October 7th of this year, President Obama signed a law rescinding the expansion. And then on top of that, he left it up to each individual state to determine whether or not to expand their definition of small group. And so some states have left the definition of small group at 50, and then other states have elected to have the definition of small group be 100. And so you'll each need to check with your individual states or contact us, and we can assist you with that. Now, employers that are under 50 employees, and depending upon, of course, what the definition of small group is, maybe 100 in 2016 forward, are also impacted in multiple ways. And the first is community rating. And this depends on the carrier, but what this means is that carriers issue non-grandfathered plans members. They're all part of a single risk pool. Rather than standing alone, they're part of this greater community rating. Also, plans may have age-banded rates versus composite rates. And so, for instance, under an age-banded plan, you may have a 20-year-old, a 30-year-old, and a 40-year-old that are all insured under the plan, but they will each have rates dependent upon their age. And so the 20, 30, and 40-year-old will all have different rates. There are also fewer plan types being offered going forward. There are a number of mandated benefits that are driving the cost, and these include coverage of clinical trials, pediatric dental and vision, and there's also some other mandated benefits. Also, small employers are subject to the 90-day maximum waiting period. There is also information that if you have as a small employer, if you have a self-insured plan, that you need to provide reporting. And so if you are an applicable large employer, this means you have to prepare the 1095-B. And if if you're not an applicable large employer, you do the 1095-B. And then if you are an applicable large employer, you report on 1095-C. Also, all small employers must provide the summary of benefits and coverage to all eligible employees. Now, employer health care arrangements are no longer allowed, and that is you're no longer allowed to reimburse employees for medical premiums. If you give employees insurance to purchase money to purchase coverage, it's going to be taxable. Now, there are a number of things that determine the large employer status. And so these include, so really, how many does it take for you to be a large employer? How many employees? If you have more than 50 full-time equivalent employees, you're going to be subject to the Affordable Care Act. And you're going to have to offer coverage or be subject to a penalty. Let's say you have fewer than 50 employees. Well, the Affordable Care Act looks at both part-time employees to determine full-time equivalents. So if you have a total of fewer than 50 full-time and full-time equivalent employees, you aren't going to be subject to the ACA and to the penalty. Now, let's say you have a total of full-time and full-time equivalent employees that's at 50 or greater employees, then you will be subject to the mandate. So let's say you own separate businesses, and if under those businesses you own 80% or more common ownership in multiple businesses, then all of those businesses would be considered part of a control group and would be subject to the mandates under the ACA, and if you don't offer coverage, would be subject to a penalty. Now, in order to calculate the full-time equivalent, first you need to look at your full-time employees. And remember, the full-time employee definition is those employees expected to work 30 or more hours per week. Now, to calculate your your part-time full-time equivalent number, you add the hours of all part-time employees together, and that is part-time hours worked during the calendar year, and you divide that by 120. And that will give you your part-time equivalent employee count. Now, calculating your full-time and full-time equivalent for each month, if these numbers are added together and they're 50 or more for the preceding calendar year, and remember, you need to include control group employees if you own multiple businesses, then the employer is considered to be an applicable large employer, or ALE, for the upcoming year. Now, there are several employee types who fall within the count. And so temporary employees are included in the count. Your seasonal employees are included for ALE, but there's a special exception if it satisfies the definition of a seasonal employee, and they're not included in the penalty calculation. So the exception, so if the employee count exceeds 50 employees in fewer than 120 days, or the seasonal workers were the only reason the 50 employee threshold was exceeded during the period, then they would not be included in the count. Owners, unless they're treated as employees, are not included in the account. You can also exclude veterans from the applicable large employer count. And you must include control group employees. Remember, all employees that work for commonly owned businesses, that is 80% common ownership, in that ALE count. Independent contractors aren't considered in the count, but if you're misclassifying those, there can be serious penalties associated with that. Now, there is some transition relief available for 2015. So an employer is allowed to use a shorter period to count their employees for ALE status determination in 2015. So they may use a consecutive 6-month period chosen by the employer. And then from 2014, they had to use a 6-month consecutive period. Now, variable hour employees, and this is probably the most difficult portion, is how you determine those is employees expected to work less than 30 hours per week. Now, you still have to review variable employees over your measurement and look-back period, and if they are averaging 30 or more hours a week, they must be offered benefits during the corresponding stability period. At this point, I'm going to turn it over to Kim Troop.
Thanks, Mary Beth. So we want to continue talking about ACA and specifically look at the penalties for the applicable large employer for noncompliance. And in particular, we want to look at, there's really 2 ways penalties can be triggered. If you look at the sheet, you can see that an applicable large employer can trigger a penalty if they don't offer benefits at all. And in that scenario, failing to offer coverage triggers a $2,000 penalty to $2,000 for each full-time employee minus the first 30 employees, and that's the penalty for employers that don't offer benefits. For the year of 2015, instead of subtracting 30 employees, you actually subtract 80 employees. But moving forward, that is the penalty for employers, large employers that don't offer benefits. There's also another way a large employer could trigger a penalty, and that is offering coverage to their employees. Perhaps they have a medical plan in place, but if the medical plan, if the cost of coverage is not deemed affordable or does not provide minimum value coverage, and an individual goes to the exchange and receives coverage and receives a premium subsidy, there's a $3,000 penalty for each individual that goes to the exchange and receives a penalty, receives a subsidy. These are really the 2 ways that the mandate, the penalties can be triggered, and both of these penalties occur when an employee goes to the exchange and gets a subsidy and has coverage through the exchange. So for the year 2015, there is an additional transition relief for those employers between 50 and 99 full-time equivalent. And essentially, they are not subject to any of the employer mandate penalties for the year of 2015. There is some criteria that you do have to meet in order to qualify for this transition. And these are things like you can't have materially reduced your medical coverage. You can't have reduced your workforce in order to squeeze into that 50 to 99 FTE status, and you can't have modified your plan date. Provided that you qualify for those things, most employers will, between the 50 and 99, will have no employer mandate penalty applied to them for the year of 2015. So let's talk a little bit about, again, the employer, the large employer that's offering a medical plan but has to meet this affordability definition. And in the statute it says that the cost for employee-only coverage for the lowest plan that's offered can't exceed more than 9.5 of the employee's adjusted gross household income. And you say, how in the world do we know what that threshold is? Employers really don't. So they can use 3 different methods, safe harbor methods, for determining that 9.5%, that affordability standard. And the first of those is to use the employee's W-2 wages for the current year, and that's a box 1, and that's a taxable wage, not a gross wage. And as long as the employee-only contribution for employee-only coverage for the lowest plan doesn't exceed 9.5% of that box 1 wage, your plan would satisfy the affordability test. Another method that you might choose to use is the employee's contribution can't exceed 9.5% times their hourly rate multiplied by 130. And the 130 is 130 hours is an equivalent for a 30-hour employee, the number of hours they would work each month. So that's another method for calculating affordability. And then the last option is just to use the federal poverty level. So if your plan for employee-only coverage, if the employee paid no more than $93 a month for employee-only coverage, then you would satisfy the affordability standard of the plan. So that's one prong of the affordability test. If a company is offering benefits that you do have to satisfy to avoid a penalty. The second one, which we won't spend much time talking about, is minimum value. And essentially, this is an actuarial calculation. The plan has to cover at least 60% of the total allowed cost under the plan. Most employers could contact the insurance company or ask their broker, or can actually even go to this minimum value calculator to determine if their plan meets minimum value. And most of the plans that we see do meet that threshold and satisfy the minimum value test. So let's just quickly talk through an example of how a company might trigger a penalty. So in this situation, again, we're talking about the applicable large employer. If they offered coverage, they had no medical plan in place and they had 75 employees. In the year of 2015, they pay no penalty because they have 75 employees, and then for that first year of 2015, it's a $2,000 penalty times each full-time equivalent, but you subtract in 2015 the first 80 employees. So in that scenario, that company would not have an employer mandate penalty for 2015. But in the year of 2016, you take that same 75 employees, subtract the first 30, and again, this is a company that is not offering benefits, multiply that times the 2,000 per each employee, and they would actually trigger a $90,000 penalty for 2016. Those penalties are assessed on a monthly basis or calculated on a monthly basis. So they account for new hires that may be in a wait period or employees that may come and go throughout the course of the year. Here's another example, and here's an example of a company that is offering benefits, but perhaps they have failed either the minimum value or the affordability test. Perhaps for their employees, they're paying more than that 9.5% for employee-only coverage. And in that scenario, if any single employee went to the exchange and purchased coverage and got a premium subsidy, the company would be on the hook just for those individuals that went to the exchange and got a premium subsidy, and that would be $3,000 for each employee. Again, that same type of penalty is calculated on a monthly basis. So again, as Mary Beth alluded to earlier, probably one of the more challenging parts of ACA is determining who do we have to offer benefits to. Well, for applicable large employers to avoid a penalty, in the year of 2015, they have to offer benefits to at least 70% of their workforce. In the year of 2016, that'll be 95% of the workforce. And that'll essentially kind of limit the ability for some smaller companies or large employers to offer maybe management-only type of benefits. And in that sense, they wouldn't satisfy these two thresholds, the 95 or the 75% threshold. So benefits have to be offered. If you're offering benefits, benefits have to be offered to full-time employees. and that full-time employee definition is now changed, and it's no longer full-time is not 40 hours, but full-time is defined as 30 hours a week. And then additionally, and we'll talk about this a little further, we do have to go back and evaluate our part-time and variable hour employees to capture and look at their hours worked to see if we need to offer them benefits, if they're actually triggering and working in excess of 30 hours. So probably the first thing that's important is to understand with ACA comes some changes in definitions of our categories of employees. So full-time is, the 30-plus hours a week. A variable hour employee is an individual that we hire on the front end, and their schedule is somewhat uncertain, or it's variable. And we're not sure on the front end whether or not they're going to work 30 hours a week or more or not. That's a variable hour employee. A part-time employee is an individual that we hire, and we expect their schedule to be a fixed schedule working less than 30 hours a week. A seasonal employee is an individual that we would hire that works less than 6 months. Typically, it would be an individual that would come back and would work the same time period each year, seasonal, like a lifeguard, for example. And those individuals are considered seasonal employees. So what happens for benefit purposes, the large employer, of course, we understand we offer benefits if we're offering a plan to full-time employees. But then we also have to look at our variable, our part-time, and our seasonal employees and determine their hours and see if we need to offer benefits to them. There's essentially 2 different ways that we can go about making that assessment about our part-time, our seasonal, our variable hour employees. The first one is to do a monthly measurement period. And this is probably the least common, but briefly, this may be a logical way for a company that has very defined work hours and has very few part-time variable hour employees. And essentially, in this scenario, an employer looks back at the prior month to determine if the employee worked the average of 30 hours a week. If they worked the 30 hours a week, they actually should have been offered benefits, and a penalty would be assessed for that 1 month. And so, again, this only makes sense for employers to use this method for with variable hour employees that have a very, very consistent work schedule. The second alternative, and is probably the most common, is to employ what's called a look-back measurement period. And this is probably the most convoluted and complicated part of ACA. And certainly your HR team is prepared to sit down with you and help you work through this if you are an applicable large employer. But essentially what happens is you then have the obligation to go to do a look back and count the hours of your part-time, variable, and seasonal employees. And whatever that look back period of time is, it has to be at least 3 months. Most employers are doing a 12-month look back. Essentially, you look back during that period of time, and if you deem that that employee worked on average 30-plus hours a week, you then, for that same 12-month, in this example, period of time, have to offer coverage to that part-time individual, irregardless of whether or not during that stability 12-month period the employee's schedule maybe changes and maybe they suddenly drop to 25 hours. So you look back in a measurement period, you have an administrative period of up to 90 days to do all your counting and determine who of your variable hour employees should be offered benefits. And then those variable employees have to be offered benefits for the full duration of the stability period. One of the things related to all of ACA and the employer mandate and the individual mandate, the IRS, who's responsible for all these calculations, will be actually collecting information from individuals and from employers and from health insurance companies to make these assessments about the individual mandate penalties and the employer mandate penalties. And there are new tax filings that are coming up effective in January of this year for the applicable large employer that we'll talk briefly about, and we will be working with our clients to help ensure that we can help you get your filings done and get them submitted. But essentially what's happening is in this flow chart you can see employers, the large employers are collecting information about the types of plans, who was covered on the plan, was the plan affordable, was it minimum value, submitting that to the IRS and submitting a form to the employee as well. Insurance companies are doing the same. They are providing a tax form and sending that to all individuals, informing them that they had coverage, and that's the basis of when the employees filing their taxes in 2015 for them to avoid the individual mandate penalty. They'll have the form from the insurance company, and if that employee worked for a large employer, they'll also have a form from their employer as well. So let's just talk briefly about these two forms. So again, the large employer, and again this is 50 plus FTEs, they will have a form 1095-C that's given to the employee, and it's generated essentially at the same time we're generating W-2s, and it essentially provides the employee information of who the employer is and who the carrier is and the months that they were covered on the plan. Additionally, it lists any of their dependents that are covered on their medical plan. There's also a separate filing that is submitted to the IRS, the Form 1094-C, which essentially is a cover sheet, and it provides additional information and provides copies of all the 1095-C forms that are going to employees. And that's submitted to the IRS by the end of February in 2015. Health insurance companies, like I mentioned, they will be submitting a Form 1095-B to all employees that are covered on the plan. So irregardless of whether or not you're an applicable large employer or not, if you have a group plan in place, your employees will receive from the health insurance company a 1095-B form, and that's again what they will use when they file their taxes in 2015. Again, if you are part of a control group, that filing can be done. It can be done separately at the separate FEIN entities, and you will simply list the other members of your control group so they are on the consolidated 1094 filing. Like I mentioned, the 1094, the 1095-C form that's generated and submitted by the large employer, that's due to the employee January 31st, and then is submitted to the IRS by February 28th. There is still right now a requirement if you meet a size threshold of 200 1095-Cs, it has to be filed electronically. And again, since all the PEO divisions will be working with our clients to ensure that we help you get these filings done and submitted timely. Couple final things as we're wrapping up. There are a couple of the auto enrollment that was slated for large employers. That just recently has been rescinded, and so that's good news for larger employers. The non-discrimination testing is still on hold, and once that goes into play, there will be some changes some employers will have to do in terms of maybe some carve-outs or maybe some changes that they're making, because it will require that all employees are paying the same amount towards their coverage, and won't give us flexibility for different amounts for managers versus employees. The Cadillac tax, which has gotten a lot of press, still is on slate for 2018. of course, as we know, with the upcoming election, there could be a lot of impact and still changes related to ACA. Certainly, this law is very confusing. There's a lot of complexity. The PEO teams have been working very hard. We've developed an ACA compliance plan, and in the near few weeks, you should expect to hear from your HR teams from the PEOs helping you work through some of the changes and some of the compliance items that will be coming up in the early part of 2016.
All right, thank you, Mary Beth and Kim, for this updated information on ACA today. At this time, while we give all of our attendees some more time to submit some of the questions, I would like to remind all of you of our upcoming webinar. Our next webinar will be January 21st in 2016, where attorney Jonathan Driggs will join us to present hot HR issues for 2016. Looking at the questions. And at this time, there actually are no questions. So thank you very much for your participation. Thank you all again for attending today's webcast, and we look forward to seeing you again in the near future. This concludes today's webcast. Enjoy the rest of your day.